All right, welcome back. Welcome back. Last day of class. It's so hard to believe. The semester seems to fly quicker every year. I know you don't feel that way, but it does for me at least. So today's the last day of class. We're going to have a final exam review session. What did I say? It was the 10th, was it? Yeah, the 10th. I'll check my calendar, double check. 10th, I think it's going to be 10 a.m. I'll double check the room, but I think it'll be 10 a.m. Let me just double check that. I want to just double check the room. Okay. I'll be around today, probably about 5 o'clock. If anyone wants to stop by. I'll be here tomorrow. We have a faculty meeting at 10 and the thing at 1. So maybe if you want to come by tomorrow afternoon, just send me an email. But I'll be around tomorrow if you want to stop by also. Okay. We have these, we're interviewing new candidates for jobs. So they have to come by and there's an interview and there's like all these things you have to do. So I'll be in and out of my office. So I'll be around though. I don't know exactly when I'll be, but I'll be around. Okay. Questions and things on your mind? Nothing? Nothing? What's that? Who's that? Exactly. Yeah, Anthony Kennedy. That's just today's class. I don't like teaching this class, if you couldn't tell. I just have so much difficulty because there's nothing for me to teach. It's passing laws, discriminates gays is bad, so it's unconstitutional. I mean, that's basically it. I can say it in one sentence. It's unfair to treat gays differently, so these laws are bad. That's the class, but I'll do my best. We have today 4 cases that were decided over the course of about 20 years. The first is Romer versus Evans. The second is Lawrence versus Texas. The third is United States against Windsor. And the fourth is Obergefell v. Hodges. Now, it's very easy for all of you to sit here in the year 2019 and say, oh, yeah, there was just 4 cases decided one after the other, and that's where we are today. But this was a process that happened over basically 2 decades. Everyone recognized where this was headed, that is, gay marriage. Everyone knew where it was headed. And the court sort of strung out this process over the course of many years as society itself evolved on the issue of gay rights. And at each juncture, you had Justice Scalia dissenting bitterly, saying, what are you guys doing? This is going to open the door to gay marriage. And at every juncture, they said, no, this is not about marriage. It's not about marriage until it's about marriage. So this was like this sort of, like a train, right, on a track. And we knew what the end of the track was, but just the train took a lot of sort of weaves and detours to actually get to the final destination. Okay? So I want to start with a poll question that will get us thinking about the first case, Romer. See if I can get the poll thing started. Oh, damn it. Okay, I'll take. Hey, I'm in class. Can I call back a little bit later? Thanks. Okay. Sorry about that. All right. I'll come back later. Okay. So I can't. I try to be nice. I can't win. I can't win. I'll come back later. He's a very good friend, and that's why I had to pick it up. Silence. Okay. What's that? My bookie. Oh my God. If I placed bets to be on the Supreme Court, and I would not win very often, I think I'd lose more often than not. No, I would not be a good gambler. Okay. All right. So the question that I want to pose to you is this: is it a rational basis for Colorado to mandate that all the local municipalities have a uniform policy with respect to sexual orientation discrimination? That's your question. And that's why I want you to start thinking about the Romer case. All right, another 10 seconds or so. All right. So let's start off. Who am I up to? Who's next? Oh, there you are, Nancy. Thank you. Nancy, let's start off one at a time. What does the phrase rational basis mean?
It generally means that if it can help, like, the society somehow, or like if it can be reasonable, like if
Just the phrase rational basis. We've used that phrase, in a number of classes. What does rational basis mean?
just something that can help them get to like the needs, something
Well, I think you're overthinking. You're talking about the various tests we talk about, but what does the word basis mean? Just forget rational. What does basis mean?
the way of how they're doing it.
Well, it's not the how, right? Let's say Nancy asks a question. It's like, you're doing something, right? What is the basis for your decision? Right? What am I asking you? Not how.
My motives.
Why? Very good. The justification, right? The word basis is why are you doing something, right? What is the motive, right? What is the motivation? What is the purpose, right? Why are you doing X? Right? Whenever I ask you what's the basis for your action, you're asking why are you doing this? Why are you doing this? What's your reasoning, right? Okay, so Nancy, I'll come back to you. What does it mean to have a basis that's rational?
Something that can help you get to your motive.
Well, but what does the word rational mean? Right? How does rational modify basis? What does that mean? What's the word rational mean?
I can think of like something adequate to get into my motive.
Okay, I'll just take part of it. You said adequate, right? How about it makes sense, right? The concept of rational basis is, does it make sense, right? Is what you're doing, does it make sense? Does it necessarily mean persuasive? No. Does it mean logical? No. Does it mean, really, really persuasive, really, really well-reasoned? No, right? All of us make decisions all the time. Some decisions are better than others. It's true, right? Sometimes we make a decision that's really well thought out. We consider all the options. We reject some options, say, no, that won't work. Here's why this won't work, right? We make well thought out decisions. And sometimes we say, well, that's good enough. Yeah, I'm in a hurry, whatever. It's fine, right? We all know, right? We're all humans, right? It's like, well, yeah, this is probably not the best thing to do, but I need to do it, right? I probably shouldn't speed, but I'm in a hurry, right? I probably shouldn't jaywalk, but I don't feel like waiting for the light to change, right? I probably shouldn't eat that extra piece of pie at Thanksgiving, but it's really yummy, right? We all make excuses, and we all do things that aren't always well thought out. That's human nature. Okay, now what about when you're the government, right? When you're the government and you pass laws, some laws are going to be really, really well considered, right? There's lots of deliberation, there's lots of debate, and everyone agrees we have to take a specific action, right? Think of like a declaration of war, right? Where we've just been attacked at Pearl Harbor, and everyone agrees we need to strike back at Japan, right? Okay, that's a well-reasoned decision, right? Or maybe you have laws that, maybe there's some chemical that's killing people, and it's being put into food, and you say, we have to ban this chemical. Okay, you have some science, you have some evidence. Okay, we gotta ban this chemical. But then you have other decisions that aren't so well thought out. And I'll use the Japanese example in Korematsu, right? Why did they ban why did they require all Japanese Americans to go to the internment camps? Well, maybe it was for national security, but it was probably based on a belief that the Japanese people can be trusted. There wasn't much evidence for it, but it was based on perhaps a prejudice, whatever word you want to use, right? Why were all the laundry licenses denied to the Chinese people in San Francisco? Well, there wasn't really any rationale. They just didn't want the Chinese people taking jobs away from the Americans. Okay, so some government decisions are well supported, and others are, maybe based on improper motives. The courts don't always demand the same justifications, right? In some cases, the court demands very rigorous justifications for law. Why are you rounding up people in camps? And in other cases, the court simply demands a rational basis. Is there some reason why you want to take this action, right? And the phrase rational basis is a specific term of art, right? The court generally uses the phrase rational basis to mean, is there some conceivable justification why you're doing this, right? Is there some reason why you want to take this action? It doesn't have to be a good reason. The reason doesn't have to be persuasive. Just be some reason. Why are you doing this? Okay? So how do you know if a rational basis is required, or if you have to give a more compelling, persuasive justification? In the context of the Due Process Clause, the court has given scrutiny tiers, right? They've said, when you have a law that violates a so-called fundamental right, we need a better justification to violate it, right? When a law infringes on a fundamental right, we need something more. We need something persuasive, right? We need a compelling interest, right? Something very significant. But when you're dealing with a non-fundamental right, basically everything else, all you need to justify infringing that right is a rational basis, right? Oh, by the way, I just got an email back. It will be in 517 at 10 o'clock for this review session. So just put that in your calendars. 517 in this clock in this room. Okay. But when you have a non-fundamental right, only a rational basis is required. What makes these four cases so difficult for me to teach is they don't fit in with the framework I just spent you 3 weeks teaching. They don't. I can't pretend they do. They don't. And the reason why is that Justice Kennedy doesn't like scrutiny. Doesn't really care about it. It's never important to him, right? It was never significant to him to develop any sort of rule that would apply consistently. For him, every case was a case to itself. You have a rule for this case, and the next case you do something different. There was never any attempt to make a generally applicable theory that can help resolve many disputes, right? Words like dignity, which we'll talk about, I don't know what that means. I still don't know what it means. But it doesn't give you any sort of framework to understand these decisions. So let's talk about each of these cases in the abstract, right? Why did Colorado enact Amendment 2? Well, I think the obvious reason is people didn't really care much for gay people, right? They didn't want them getting special protections. True enough. I think people would probably acknowledge that those immoral conduct which should not be protected by the state. That was probably one of the motivations, if not the primary motivation. But were there alternate motivations? Let's see what people put here. Wow, look at that. Look at that, you guys. Wow, that's right down the middle. Oh, man, I've never had that before. It's 50-50. Oh, boy. Well, okay, then. Well, let me talk about this for a minute. Right down the middle. Now, I think the people who put false were answering actually a different question, but I'll explain why. When I say, is it a rational basis, right? I'm not asking, was this the actual justification the government had? Generally, with a rational basis review, We're not asking what in fact motivated the government. We're asking is what could be a justification. So if you have a state of Colorado, right, and you have a business, let's say you own a Casa Bonita, it's a restaurant chain in Colorado. You want to watch a South Park, you know the reference, right? It's a real reference. It's a real restaurant, by the way. And you have restaurants in Denver, Boulder, and Aspen, and all these other cities, right? You have a business statewide. You want to have an HR department, right, that understands what are the rules of the state you're living in. It creates some complexities to have different employment discrimination regimes in different cities. Could the government say we want to rationally limit the number of laws businesses have to comply with by setting a single standard statewide? Is it a rational basis? Absolutely it is. Is that the reason why Amendment 2 was enacted? Absolutely not. So what do you do with that then, right? Right? Very often the government will enact the law for reason A and come to court and defend it with reason B. And in almost all cases, the court says, oh, that's fine, right? We don't demand the actual reason the government acted with because that's too rigorous. You only demand that when there's some sort of fundamental right is at issue. The difficulty with Romer is the court never recognizes a fundamental right. They don't overrule Bowers against Hardwick, but they apply the same sort of strict scrutiny you would see in a strict scrutiny style case. Right? Same for Windsor. Right? The court never recognizes a fundamental right, but they discard the government's stated interest in having the Defense of Marriage Act. Right? And then finally, when you get to Obergefell, the court begrudgingly suggests that marriage is a fundamental right, but they don't go much further than that to explain what that right entails. Right? What does that right mean beyond just a marriage license? Does it mean you can then discriminate against gays and lesbians in contexts other than marriage? Some of these unsatisfying decisions that sort of left open the big elephant in the room. Right? Does denying certain protections beyond marriage violate the protection clause, which is where you think most of this comes from? So these cases sort of build up to Obergefell, but in a sort of haphazard fashion. Okay. All right. Questions so far? Nick, are you next?
Yes, sir.
Okay. Nick, let's start with Romer against Evans from Colorado. That was in 1996. Just give us the facts there, please, to start.
Okay. I guess there were some laws or regulations that were protecting homosexual discrimination, and so you kind of touched on it, but the state passed Amendment 2, which repealed these protections against discrimination against sexual orientation. And that's how it got to the Supreme Court. We were challenging that it was unconstitutional to repeal this protection that the government afforded these people.
Okay, very good. All right. Colorado at the time was a bit of an odd state. It was a fairly conservative state, but there was some very liberal pockets. Denver, Boulder, Aspen, and a few other cities. A couple of these cities began to enact laws that prohibited discrimination against gays and lesbians. Okay? This applied in employment contexts, but also in housing contexts. A movement sprung up statewide to try to repeal these ordinances. Now, how does this work? The state constitution was amended by popular referendum, called Amendment 2, right? And when you amend the state constitution, that wipes out these local ordinances. And what the state amendment basically said is that it's now against state law to provide protections to people on the basis of their sexual orientation. Okay? The Colorado Supreme Court declared Amendment 2 unconstitutional. right? But that was based on the 14th Amendment. And it was kind of a weird decision, but they argue that laws that violate the political process are reviewed with strict scrutiny. The idea was basically footnote 4 of Caroline Products, that gays and lesbians were this discrete and insular minority, and you had a law that targeted them and interfered with the ability to impact the political process. Therefore, the Amendment 2 is reviewed with strict scrutiny, and they found that the state did not have a good enough interest to withdraw these protections. All right, that was the state Supreme Court decision. The U.S. Supreme Court affirms, but on very different grounds. So, Jonathan, can you just walk me through briefly Justice Kennedy's analysis?
Right. So he says that they violated the equal protection, and because the Colorado was a law that was declaring that it should it's more difficult. The Colorado law was more difficult for the gays or that group of citizens to seek aid from the government than the other citizens. So they were denying equal protection of the laws and the federal census.
Okay, so let's think about this, right? Generally, if you live in the city of Aspen or Boulder, right, and you want to make a change to government, who do you have to call? You call up your city council member, you call up the mayor, right? You call your local government. And in general, your local government can make changes to accomplish certain goals. What if you're a gay person who lives in Aspen and you want to call up your local government to amend the laws to prohibit discrimination? Can you do that? The answer is no. Rather than just calling up your mayor and your city council, you have to call up the entire state. And you have to have a referendum on the constitutional ballot to change it. In other words, most laws can be changed fairly easily, with the exception of this one law, right? An additional burden was placed on this one law to make it harder to modify. So the court suggests that these burdens are placed only on gays and lesbians and no one else. And therefore, this is a violation of the Equal Protection Clause. But wait a minute, Josh. Didn't we just have this entire unit about these 3 tiers of scrutiny, right? Where we say racial classifications are really bad. We review those. We review laws that burden racial classification with strict scrutiny. And then gender classifications are, kind of bad, but not always. So you kind of review those sorts of laws with intermediate scrutiny. And everything else is rational basis, right? Everything else is a rational basis review. And I think the state argued that this just maintains a single set of laws statewide. Isn't that a rational basis? I think it would be. The missing ingredient in this case is a discussion of where classifications in the basis of sexual orientation fit in. There's just no discussion of whether a classification on sexual orientation is suspect or quasi-suspect or non-suspect. There's just no discussion because Justice Kennedy doesn't care. Now, why doesn't he care? That's the more important question, right? I can give you a couple of reasons. I don't know if any of them are accurate, but I can speculate a bit. One is that once you acknowledge that sexual orientation is a suspect classification, then the justification for gay marriage laws goes away, right? If you argue, and I think Justice Stevens makes this point in Bowers, candidly, if you take the position that you need a compelling interest to treat gays and lesbians differently than straight people, why then, what's your compelling interest is in either marriage licenses, right? The rationale traditionally is that maybe gay relations are immoral, or perhaps that children aren't safe. Those are all things that can be tested and would not likely survive a strict scrutiny analysis. So I think the court is very hesitant, at least in 1996, to state that sexual orientation is a suspect classification, because that would basically make it a fait accompli, that is predetermined that gay marriage is constitutional. Now that's maybe one reason why the court does it like this. I think the other reason is that Justice Kennedy just doesn't care. His entire mantra is, I don't want the government treating people poorly for improper motives, and I can decide what those motives are improper, right? How do judges know what a motive is that's improper, right? What tells us in the Constitution that you can't treat people differently based on morality, right? Bowers upheld that rationale, but but now you have rumor chipping away at that holding. Right? Who says? How do you know that's the case? Right? Well, why are judges in a better position to decide the wisdom and propriety of laws than those who are in the elected branches? But Justice Kennedy never grapples with that. He simply says, when the government acts for an improper motive, the courts can step in. Okay. All right, so let me walk you through the Romer opinion. It's not very long, but I think it gives you the flavor of what Justice Kennedy had in his mind that day. He describes this law as somewhat unprecedented. In that case, he's correct. Right? You don't have a tradition of laws that withdraw protections from people. Usually, it's you adding protections, right? You don't have laws that withdraw or take away protections. And he says this law is frankly unprecedented. It treats people as strangers. It puts them in a solitary class with respect to the government. Okay? The law imposes a special disability on those people alone. And the only way they can achieve a change is by amending the state constitution. Okay? But then we go to this, talk about scrutiny. He says, well, we're just going to apply the rational basis test. This case did not apply traditional rational basis review. It was somewhat similar to Cleburne. And Justice Kennedy cites a case called Moreno from the 70s. And this was a case which never really was that important until Kennedy discovered and seemed to love it. It's a Brennan opinion, of course. And at one point in Moreno, Brennan writes, if the constitutional conception of equal protection of the laws means anything, it must at the very least mean that a bare desire to harm a politically unpopular group cannot constitute a legitimate governmental interest, right? That if your only reason you're acting is to harm people, then you're not acting with a legitimate interest. I don't know if that's even true. Lots of laws are directed to harm people, right? There are lots of laws passed that are designed to punish rich people, to punish poor people, to punish criminals, right? We have lots of laws that are designed to harm people. I don't even know why that's true as a matter, but Brennan wrote it and Kennedy seems to like it, right? But the concept of a bare desire to harm suggests that you're only motivated by desire to harm. And Kennedy discounted the motivations. No, you're not really motivated for other reasons. This is why you're doing it. And that's a sort of strict scrutiny thing. No, that's not the real reason. That's the real reason. Here's really why you're doing it. Okay? So in short, the court holds that Amendment 2 classifies gays and lesbians. By the way, just notice the language. He uses the word homosexual here. He does not use that word in Obergefell. That word just vanished from the vernacular. You can even just see the language, how they're talking about gays and lesbians evolved over 20 years. Scalia, too. We'll get to Scalia in a minute. But he says, Amendment 2 classifies homosexuals not to further a proper legislative end, but to make them unequal to everyone else. Colorado cannot do this. A state cannot so deem a class of persons a stranger to its, I can't finish a sentence, to its laws. It's just, when I read Kennedy, it's like a B+ philosophy paper, right? You know, it's like if you're like a freshman composition class and you ask to write a paper on why gay marriage is a good idea, this is the sort of thing I would expect. I'm sorry, I get this way every end of the semester. It's a lot of pent up frustration. I read these cases every year, I'm like, what? If Ginsburg wrote this opinion, it would have been awesome. Right? It would have been so clear and neat in describing why gays are a suspect classification and why gay sex is. It would have been so much cleaner, but this was Kennedy. And ever the price of the fifth vote, they just go along with it. There's never a concurring opinion in any of these cases. Like Kagan could run a wonderful gay marriage opinion. I would love to read it. Just not this. Okay. All right. Questions on the majority? So glad he's off the court. Seriously, I would. It just makes me very happy. I don't have to teach his new opinions as we're done. Yeah, Nick.
Have we ever, or do we currently have an openly gay Supreme Court justice?
Openly?
Or
Not.
closetly?
I'm not going to answer. I'm not going to answer that question.
Really?
Google.
Okay.
Not going to answer that question. I'm not going to answer the question.
Is that like common? Like, is it something I don't know?
The point of a closet is it's a closet for a reason, so I'm not going to answer your question, but
Okay.
there are rumors.
Fair enough. Oh, I see. You're speculating.
I'm not speculating, but yeah.
Sorry, so I was just curious if like these sorts of things would carry more weight if like the Supreme Court was writing an opinion and they were gay or something.
I'm not saying anything else. Next question. It's people's choice. I'm not going to do that. Okay. People are quickly Googling frantically. Okay. All right, let's go into the dissent then. The Scalia dissent, he keeps saying the same thing over and over again, right? It's like if you read one Scalia dissent, you've read all of them. He's livid. He's absolutely livid. And here he's livid because of a couple of reasons, right? You have Bowers, which was decided barely a decade earlier. And Bowers said the state can criminalize homosexual activity. But this case now says, but they can't withdraw protections. Scalia also says that this is a tolerant law, and that people always get kind of upset at that line. He says people are trying to evolve in a orderly fashion, not have these sort of local cities go out of line. Scalia explains that the Constitution can be changed, but through political process and not through judicial decisions. All right. At the very end, Scalia starts discussing where this is headed, right? He makes this point more clearly in Lawrence. But what he seems to be suggesting is if you start treating sexual orientation as a suspect classification, or perhaps you treat sexual relations as a fundamental right, a lot of other things start to fall apart. A lot of other structures you have in society. That is, once you decouple law and morality, a lot of the laws which Scalia would hold dearly, I think, now become constitutionally suspect. Right? I'll do more of the Lawrence dissent because I think he gets a little bit more angry there. I think he was the angriest in Windsor. And by the time he got to Obergefell, he sort of like, okay, I'm with it, right? He's like, what are the stages of grief, right? The stage of loss, like you have denial, you have anger, and then finally you come to terms, you acceptance. Yeah, I think Romer was kind of denial, and then Lawrence was like anger, and then what's the one that comes after anger? I don't remember anyway, but Lawrence or Windsor was definitely the anger stage, and Obergefell was like, whatever, I agree. Okay. All right, any other questions on Romer? All right, let's move on now to Lawrence, which is a case that began right here. I want to play a brief clip of Mr. Lawrence so you actually get to see what the guy looks like. Where is it? Okay. Okay, let's play this right here. Hope this works.
In this video, we continue our analysis with Lawrence. Justice Kennedy offered this account of the facts.
In Houston, Texas, police officers were dispatched to a private residence in response to a reported weapons disturbance. The officers observed Lawrence and another man, Tyrone Gardner, engaging in a sexual act.
They just yelled, threw me back on the couch. It's just all of a sudden we're taking you down there. Their version of the story was that they had found us engaging in sex. They did not search anything to find the gun.
A majority of the court.
Okay. So the facts of this case, I think was that Ray or was that who mentioned that last class? Yeah, it's him. Yeah, the side piece, right? Yeah. The facts of this case are almost certainly not what was in the book. This is one of these weird cases that should have never been. The reason why the sodomy laws were so rarely enforced is because generally people are engaging in these acts in the privacy of their bedroom, right? You generally do not have police officers going to people's bedrooms seeing what they're doing. Now, I suppose people can have sex in a public place, and I guess that's a different type of an offense, right? And that happens in the Minneapolis bathroom. Remember Larry Craig? You remember that story? Just Google Larry Craig in the Minneapolis bathroom. He was a senator.
Senator Larry Craig.
I'm sorry, yeah, they don't know that. Senator Larry Craig. Yeah, I actually went to that bathroom. Not not like that, but I was at the airport, and it was actually, fuck. I said to myself, no, anyway. Bad story, I actually left my jacket. Someone actually stole my jacket from that bathroom, so I think it's a cursed bathroom. But it was really bad. It was really cold in Minneapolis, too, and I didn't have a jacket. It was bad. So if you go to Minneapolis airport, just go somewhere else. Hold it in or something. I don't know. But anyway. The story here is almost certainly false, right? Lawrence was seeing a guy. Oh, let me go back and show the picture. Lawrence was seeing a guy named Garner. It's unclear if they were in a relationship, but they were seeing each other. And Garner's boyfriend apparently called the cops and we tried to get him in trouble because he was jealous and said something like, there's a black guy with a gun in Lawrence's apartment. He's trying to get him arrested. There was no gun. The cops show up. They're expecting a gun, so they kind of knock in. I don't think they had a warrant. They might have had exigent circumstances, but I don't think there was a warrant. And they've never actually even searched for the gun. But one of the cops apparently was a bit of a jerk, and he wrote them up on sodomy charges. Right? He didn't have to. He could have just given them a warning and said, "Okay, whatever, you guys go home." But he wrote them up. It's not clear they were having sex. Again, I think I told you this. One cop said they were having anal sex. The other one said oral sex. The other two said nothing. It's hard for four people to not see the same thing, right? It's an act which it's hard to mistake, and they were all confused. They're pearl clutching. Yeah, they just couldn't handle it. Whatever. At that point, the lawyers in Houston found this case. There are a number of gay rights attorneys in Houston. They said, we finally have a case to challenge Bowers. There was never a vehicle. Now, why did this case go to the Supreme Court? And here I'm going to have to make fun of an alum of this law school. The Harris County District Attorney, his name was Chuck Rosenthal. He wanted to make a name for himself with this case, and he decided to appeal this case to the Supreme Court. Right? He decided not to appeal this case, but he prosecuted this case up. He did not have to prosecute the case. He could have just dismissed the charges, but he wanted to prosecute them. He wanted to make a name for himself as a social conservative. Now, Chuck Rosenthal went to this law school, and this is kind of weird, but he randomly emails me. I don't know why, but he found me somehow and sends me things it's like he reads my stuff, so I'm now making fun of him, but he deserves it. His arguments were terrible, right? He argued the case before the Supreme Court himself. He shouldn't have. At the time, we had a Solicitor General. His name was Ted Cruz, a very good lawyer. Think of a Ted what you will, but he was a wonderful attorney, right? We had very good lawyers, but he decided to argue himself. He wanted to make a name for himself, right, to build up his reputation. He was really bad. At one point, Scalia told him, "Don't fall into the trap," and he fell into the trap. At another point, Chief Justice Breyer said, "I want a straight answer from you." Right? If a judge tells you I want a straight answer, you're not doing your job. At another point, Justice Ginsburg asked, does Texas law bar gay people from adopting children? You think the lawyer might know the answer to that. Seems like a reasonable question. He's like, Your Honor, I don't know. It was really bad. He struggled so bad. If you want the arguments are online, a website called Oyez, O-Y-E-Z, Oyez, you can listen to his arguments. They're terrible. And if you're watching this, Chuck, I'm sorry. Advocacy matters. Now, I don't think he would have actually helped the case. I think he was going to lose anyway, right? But at least you can have a better person arguing. All right. The vote in Obergefell was 6-3, although it was really five votes for the Kennedy opinion. O'Connor was by herself with her own separate one. But the Kennedy opinion, oh God, let me see if I have to play it. I can't read it. Where is it? All right. The Kennedy opinion begins, liberty protects the person from unwarranted governmental intrusions into a dwelling or other private places. In our tradition, the state is not omnipresent in the home. And there are other spheres of our lives and existence outside the home where the state should not be able to be a dominant presence. Now, that's all about the Fourth Amendment, right? Meaning the government can't search your stuff. I think that makes sense enough. But then we go to this part. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. And here it comes. The instant case involves liberty of the person, both in its spatial and in its more transcendent dimensions. I don't know. He's trying to channel Justice Blackmun's dissent in Bowers against Hardwick. If you remember, Justice Blackmun and Bowers said that liberty involves spatial and decisional planes, maybe that sort of line. He's trying to channel this, but now this is a majority opinion, not a dissent. What this tells us, though, is this case is not about equal protection. It's about a due process case. And the argument is that the due process liberty interest in having these sorts of relations is protected by the Constitution. That's what this beginning tells us about. The Texas law was different from the Georgia law in one important respect. The Georgia law prohibited all forms of sodomy, heterosexual and homosexual alike. The Texas law only applied to gay couples. That is, a husband and wife could engage in anal sex, but two guys couldn't. That's how the Texas law was drawn. All right. Who's up? Dylan, you want to walk me through as best as you can the Kennedy opinion. There's a lot going on, but just start it, and I'll ask some follow-up questions.
So basically, same-sex couples seek in marriage the same legal treatment as the opposite-sex couples, and it would disbarred their choices and diminish their person that you deny them such rights. Okay.
All right. So let me ask you this question, Dylan, right? What were the tests we usually follow to decide if a right is fundamental? What tests do we apply with the due process clause to categorize various types of rights? What are the two tests that we talked about last week or last class? There were two tests we talked about.
Was one the undue burden?
That was a test from Casey, not what I'm thinking of. Can you check your notes from last class? There were two frameworks we used to analyze due process cases historically. Mitchell? Yep.
What, the deeply rooted?
Okay, that's one of them, right? One of the tests with the due process clause we ask, is this a right that's deeply rooted in history and tradition, right? We look at history and tradition. And the other test, anyone know what it is? Yeah. What?
Morality?
No. Who said it? Yes, all together, yeah. Fundamental rights, right? This concept is this right that's implicit in the concept of order, liberty, whatever the hell that means. Mitchell, does Justice Kennedy think that a right to homosexual sodomy is deeply rooted in history and tradition?
Not necessarily, but he does state that people should have the liberty to do what they want in their.
But what about history? What does he say about history? Does it matter whether this right's deeply rooted? No. Okay, so here Kennedy sort of rejects the deeply rooted test. He says, our laws and tradition in the past half century are of most relevance here. They show an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives. In other words, even though this right is not deeply rooted, we don't care, right? We look to more recent positions about gay rights. Many states have decriminalized sodomy. International courts have decriminalized sodomy. There are lots of law review articles and papers and books written. That's good enough for us. this is the first part of the Kennedy modification of substantive due process, that it doesn't matter if a right is novel. Even new rights, newly understood rights, evolving rights, all these rights can be treated as if they are a fundamental right, although he never really uses that phrase. Okay? Okay. And as a result, he basically says this is a right that's very important. And the state, well, Amy, what interests does the state assert, right? What's the basis the state gives to enforce this law? Why does the state enforce this law?
I don't remember if this was the case when they mentioned it, but didn't they say it was like for the kids or something and adopting?
Well, that's more the marriage decision, but generally speaking, how do you think Texas defended its ban on homosexual sodomy? Why did they criminalize this activity?
Well, because they didn't want same-sex marriage. And so
Well, marriage is a separate issue. Just focus on the sodomy for a minute, right? Why did the state prohibit same-sex sodomy? What's the rationale if you were to ask them?
because
What do they think of homosexual conduct?
it was immoral.
Bingo. That's the right answer. Right? The reason why this law was enacted was because of a judgment that certain conduct was immoral. It went against certain religious teachings, whatever you want to say, but it was immoral conduct. And that's why they criminalized it. There are lots of laws premised on immorality. Right? Why do we criminalize suicide? Or actually, it's attempted suicide. You can't punish someone who actually kills himself because they're dead. But attempted suicide is a crime. Right? Why do we criminalize prostitution? These are consensual acts. Sometimes, not always, but often they're consensual acts. Lots of countries have actually legalized prostitution. It's become a profession. It's unionized. It's an actual trade. The oldest profession, right? Why do we criminalize certain types of drug use and alcohol use? Lots of laws that we have are premised on a notion of morality, that we shouldn't harm the body, that we shouldn't put stuff in to harm each other, that prostitution is selling the flesh, whatever you want to say. Why do we prohibit selling organs? This is a question you may have studied in property, right? We have a shortage of kidneys. People die every year because they can't get transplants. You can sign up to be a donor, but you don't get compensated. If we compensated people, we'd probably get a lot more organs in the market. Why can't people sell their flesh? People's lives would be saved if we had organ markets. Right? You can pay to donate plasma, right? You go to the blood bank. You can be paid to donate semen, right? You can eggs. You can donate eggs, right? There are lots of things that you could donate to people. You can serve as a surrogate. You pay a lot of money to be serving as a surrogate. A lot of money. But why can't you donate a kidney? You have two of them. You can live a perfectly healthy life with one. Right? Why can't we compensate people upon death to donate their organs? They don't need it. They're dead. Right? We can have a long theological discussion of whether organ markets should be allowed, but at bottom, these are all laws premised on a question of what is moral, what is not moral. Here, the court says that the people of Texas cannot base their law on their sense of morality, that homosexuality is wrong. And the court says that that's not permissible. Why? It comes back to Moreno, right? That it's simply a bare desire to harm people. That's what the court says. Not to promote any sense of morality, but just to harm gay people because we don't want them to engage in relations they find, conducive to their transcendent happiness. Right? The court says Bowers demeans the lives of homosexual persons. It treats them as second-class citizens. This is the same theme we saw in Romer. They're treated as strangers in their own land, so to speak. Okay? Everyone with me so far? All right? What about stare decisis? Right? What about stare decisis? Didn't we just say in Casey that we shouldn't be overruling precedents because we have to have reliance and the court shouldn't look like it's changing its mind? Has he just overruling Bowers?
Justice Stevens' analysis should have been controlled in Bowers.
Oh no, for sure, right? He says Stevens was right, but so what stare decisis, right? Even if stare decisis, so even if the decision's wrong, doesn't Casey teach us we should stand by these decisions anyway? Right? How does Justice Kennedy square Casey, where he just said a couple years earlier we have to stand by precedent, even if the decision was wrong? What does he say?
You could, as far as like not sticking by stare decisis by going to different directions, he says because there's not going to be detrimental reliance.
Ah, okay, very good. Thank you. One of the issues in Casey was you stand by precedent. Why? We stand by precedent because people relied on it. People have structured their lives around Roe. Did anyone structure their lives around Bowers? Probably not. Right? Did anyone say, you know what, I really want to have sex with this guy, but I'm not going to because it's illegal? I suspect the answer is no. Right? To be sure, the law had an effect on people. They think, oh man, my conduct is now illegal. But people haven't structured their lives around Bowers in the same way that people structure their lives around Roe. So the court basically says there's no reliance interest here. So therefore, Bowers was wrong, was decided, it's wrong today, and as a result, it cannot remain binding precedent. They overrule it. And then the court has this little bit at the end. All right, I'll just play this.
Right to stay.
Had those who drew and ratified the due process clauses of the Fifth Amendment or the 14th Amendment known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see them.
I'm sorry. People are calling me way too much today.
Was once thought necessary and proper, in fact serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom.
All right. And that's Kennedy's own words. I think he firmly believes that the court has a unique role to determine what freedoms are important in every society, based entirely on his sense of what laws promote dignity and what laws demean people. That's his position, and he sticks to it. It's a consistent position. It's one that students have difficulty with extending to other doctrines. Of course, the difficulty is when Kennedy's on the bench anymore, these decisions have no more relevance. And not to mean that they're wrong, but I don't know what salient this sort of analysis has, right? Will the Supreme Court ever decide a case based on dignity again? Probably not. I just don't think it'll matter. So these decisions were important for the time, but they don't lay down any principles that can be extended elsewhere. All right. Any other questions in the Lawrence majority? All right. I briefly want to mention Justice O'Connor's concurrence, which some people like, some people don't. O'Connor argues that Bowers was correct because the Bowers statute prohibited sodomy among all people. In contrast, the Texas law only prohibited same-sex sodomy. O'Connor therefore said this is a classification that violates the Equal Protection Clause. She never says that gay LGBT categories are suspect. She says it's just rational basis. Probably not even accurate in its terms. But let's say that O'Connor was right. Could Texas then just modify its statute to prohibit all types of sodomy? They could. And that's, I think, why the majority doesn't want to go down the equal protection route. Okay, now, would Texas pass that statute? Probably not, for reasons you can speculate on, right? But the O'Connor opinion at least allows that the state can have some types of sodomy bans. O'Connor also cites Moreno and says that moral disapproval is not a rational basis. This gets picked up more later. At the very end of O'Connor's opinion, she says, not marriage though, right? That you can't have this classification, but you can still have marriage because it's important to preserve the traditional institution of marriage. Why? She doesn't really say, but it's so obvious at this point where this is headed that they knew what they were doing. They just didn't want to talk about it. Okay. Questions on the O'Connor concurrence? All right, Braden, let's talk about Scalia for a minute. He's really angry here. Really, really, really bitterly angry here. And he's angry for a lot of reasons, right? Give me one reason why Scalia is angry. He's pissed here.
Well, I think one reason is that they didn't come out and say that this was a fundamental or deep rooted
Good.
right, and therefore he believes that it should just be judged on a rational basis. If
Okay.
it's done on a rational basis, then they should uphold the Texas law.
Okay, very good. All right, so the first part of the Scalia opinion is, what is this, right? Is this an equal protection opinion or due process? It has to be due process. They don't talk about classifications. And if it's due process, what is the classification at issue? Is it a fundamental right? Is it a non-fundamental right? Court doesn't say. So therefore, you have to presume it's a non-fundamental right. So you're basically taking strict scrutiny to review a law that burns a non-fundamental right. Doctrinally, Scalia said this is incoherent. And I think in this part of Scalia's opinion is fair. Kimberly, though, he's also livid about stare decisis, right? Why is he he's very angry about overruling Bowers? Why is he really angry about overruling Bowers here?
So he's talking about, I'm having a mind blank right now.
What was a recent case we studied, Kimberly, that involves Scalia and stare decisis? What recent case did we read about?
Romer v. Evans,
And even before Romer.
Bowers,
Oh, after Bowers, before Romer. Sorry.
Planned Parenthood.
Yeah, that's what I'm talking about. Casey, right? In Casey, the court says we cannot overrule Roe, right, because of stare decisis. We have to stand by our precedents. But here, we can overrule Bowers, right? Kimberly, how does Scalia react to this decision that we have to overrule Bowers but not Roe?
He doesn't like how the court picks and chooses what they want to adopt.
Very good. Yeah. Right. Stare decisis is one of these things. I'm going to paraphrase, but Justice Alito once said, "Stare decisis means we stand by the precedents we like." I'm paraphrasing. That's more or less what he said. All right. When the court wants to overrule a case, they do. When they don't, they say, "Oh, we have to stand by it." This is not any sort of meaningful doctrine. It's so flexible. I don't really care much stare decisis. I think it's overrated. I think if there was really a bad decision, the people would simply change it. They'll pass a statute. Right? Even if Roe was overturned, the abortion laws in New York would look identical. The abortion laws in California look identical. I think Texas would quickly realize we can't do what we want to do because it's not very popular. So I think that this argument for stare decisis is based on this fictional universe where only the court exists and the political process is dead. But Scalia is livid, right? He's absolutely livid. But then we get to this one line, right? If we overrule Bowers, what happens next? Right? You know the line I'm talking about. He says, if we overrule Bowers, morality laws go away. He says, state laws against bigamy, bigamy is polygamy, bigamy, same-sex marriage, adult incest, prostitution, come on, masturbation. Are there laws against masturbation? I guess there are. I guess. Adultery, yes, adultery was illegal in some states. Fornication, right, which is a type of adultery. Bestiality, having sex with animals, and obscenity are likewise sustainable only in light of Bowers' validation of laws based on moral choices. Now I'm going to just pause for a minute. A lot of people think Scalia was analogizing same-sex marriage with bestiality. That wasn't his argument. What he was saying is these are all laws based on morality and different notions of morality. And if you cannot prohibit sodomy, why can you prohibit same-sex marriage or any of these other things? Now, aside on the incest part, yeah, this is one of those classes. I once wrote a blog post about adult incest, right? Why is adult incest illegal? Now people say, oh, Josh, because there might be some sort of recessive traits and they'll reproduce, right? Okay. Why is gay adult incest illegal? And I wrote this blog post once, Lord help me. Why can't two brothers get married? I got so much email about that post from people who were engaging in these relations. I got, by the way, a lot of, based on what my last name is, right, and adult incest, just think of the Google searches that came to my site. That's all I'm going to say. I got so much bad Google traffic. I had to throw up the comments in that one. Yeah, that one, yeah. Google autocorrect, right? But I got a letter from a guy in prison who was arrested for having sex with his daughter, who was an adult. This is actually not uncommon. He apparently got a woman pregnant, was out of the picture, and then like 20 years later he met the girl, and they developed a relationship. She was adult, and it was fully consensual. And he had to go to jail for this. And he actually asked me, he found my blog post somehow, I don't know how. I didn't write back. No, I did not write back, but he's like, can you help me with my case? But why is incest illegal for adults and it's consensual? If there's kids, I got consent issues, I understand that's fine. But and if the argument is they're recessive traits, we don't make people take blood tests when they get married. People who have recessive genes can get married and produce children that have a high chance of various types of recessive illnesses, right? So why prohibit incest? And the answer is we think it's gross morality. But the same thing was said in Texas about people who are the same sex. Well, gay sex is gross, right? If the answer is we think it's just wrong. Anyway, but so there are some incest cases that stay away from the courts because prosecutors recognize it would be very strange to bring these, but they do happen. Katie, you have to look in your face of just disgust.
No, I want to read this article now because I just had never thought of just.
Don't Google it, please. For the love of God, don't Google.
Well, you know what I mean.
Yeah, don't. Because you can tell what sites are linking to you, and just the sort of garbage I was getting was just really bad. Yeah, I'm gonna leave it there. But anyway, Scalia's point was we have lots of laws that are based on the idea that, wow, that's yucky, right? That's gross. Ill, two brothers, right? But it's based in some sense of morality. And at some point, the court here says, well, some types of morality are okay, but others aren't, right? I think suicide is an even better example. Why do we make it a crime to try to kill yourself? Because we want to preserve life, we want to preserve morality, we want people to live. There are lots of countries in the world where euthanasia is legal, where people who have various types of health conditions can request from the state to be euthanized. Right? We allow people to withdraw care, right? To withdraw treatment, and they basically have to just die due to lack of sustenance, right? You pull the plug, so to speak. That can often take you several days to die, which is excruciatingly painful. These are, I don't want to answer these questions now. We can have a theological discussion later maybe, but we have lots of laws that are premised on some sense of morals. And Scalia's like, once you decouple law and morality, how are those laws valid? Where do you support them anymore? Okay. Yeah, it's one of those classes, right? Scalia writes, this decision effectively decrees the end of all morals legislation. In other words, once you get rid of these restrictions, there's no reason to deny marriage license to gay people who want to get married. And he looks to, for example, Canada, where gay marriage is already becoming legalized. And at the end, Scalia says, I dissent, mic drop, no respectfully, because he was very angry here. Do I have the I dissent line? I can't remember if I put that one in there. Oh, there's a, I want you to play this.
However, the court today reaches the opposite conclusion. The decision in Lawrence effectively decrees the end of all morals legislation. In his majority opinion, Justice Kennedy attempted to limit the scope of the decision. This case, it does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter.
I wonder if he actually believed that. Right? I mean, he's not an idiot. I know I make fun of him. He was a smart man, and he was a very wise person. But how do we actually believe that? Because he had to have known what he was doing.
To this, Justice Scalia responded, "Do not believe it. Today's opinion dismantles the structure of constitutional law that has permitted a distinction to be made between heterosexual and homosexual unions. If moral disapprobation of homosexual conduct is, as the court says, quote, no legitimate state interest, close quote, what justification could there possibly be for denying the benefits of marriage to homosexual couples exercising what the court in today's opinion calls, quote, the liberty protected by the Constitution?" Justice Scalia's prediction would prove to be accurate.
All right. Questions on the Scalia dissent. I could teach an entire class on that one, but there's just he was really angry. I made this point earlier. Kennedy never responds to dissents. It was just beneath him. He just never did it. So you don't ever have this sort of back and forth explaining why you go one way or the other. All right. Any questions in the Scalia dissent in Lawrence? Thomas dissented, and he said that this law is uncommonly silly. And if you were a member of the Texas government, he'd repeal it. But that's not his role as a judge, which I think is Thomas's usual position. All right, questions on Lawrence? 2003, I mean, God, that was 16 years ago. It felt like yesterday. 16 years ago. All right, let's move on. Let's talk about Windsor and Obergefell, but let's provide some background. Around the same time Romer was decided, Congress enacts DOMA, the Defense of Marriage Act, DOMA. What did DOMA do? Where is it? Right, DOMA did a few things. DOMA determined that marriage, for purposes of federal law, would have a single definition. Okay, one man and one woman. Before DOMA, usually federal law looked to state law to define marriage, which makes sense, right? In some states, you can get married at 15. In some states, marriage you get 16. In some states, you get married at 14 through parents' consent, right? Some states allow common law marriage. Other states don't allow common law marriage. Right? Some states say you can marry your second cousin. Some states say you can marry your first cousin. Right? Every state had its own policy on marriage. And it made some sense to just refer to state law. So if a couple wants to file a tax return in Texas and they're in a common law marriage, they could file a joint tax return. But if you go to a state that doesn't allow common law marriage, then you don't let them file a tax return. Right? You just simply look to the state and where they reside. But starting in the 1990s, there was a movement to perhaps move towards gay marriage. There was a court decision in Hawaii. There were some policies in Canada, which basically gave domestic partnerships and other types of recognition to gay couples. DOMA eliminated a lot of that uncertainty. And DOMA said, doesn't matter where you're married, where you live, there's going to be a single definition for marriage nationwide, one man and one woman. Okay? Now, that was certainly a rationale for DOMA. It probably wasn't the primary rationale. Right? So, folks, let me ask you a question, right? Historically, going way back, forget gay rights, going way back, why did marriage as an institution come into existence, right? Why do we have marriage? All cultures around the world developed this independently. It's not like there was one person who said, okay, when you do marriage, like every continent on Earth, you had some concept of marriage. Why?
It intertwines with other fundamental rights such as childbearing, education, procreation.
Well, you're right about fundamental rights, but forget courts, forget constitution, right? Marriage is thousands of years old. I mean, every civilization on Earth has it in some form. Can't sneeze. Why? There it is. Why did marriage develop? Why?
Based on religion aspect?
But we have different religions. Every religion on Earth, every continent, people have different faiths. Why did marriage develop in every continent on Earth, in every country, everywhere? It wasn't some sort of collective action. It wasn't sort of plan. People who never interact with each other develop marriage.
My opinion is marriage developed because it's consistent with one's choice of identity. Like it's sacred. It's very sacred to one's being.
Why is it sacred?
Because someone is able to establish their lineage. Like,
Children.
yes, to have children and their name lives on forever.
What's the connection between marriage and children? I think you're getting where I want you to go.
Between marriage and children.
This is an easy question students have a lot of difficulty with. It's a very easy question, right? What's the link between marriage and children? Oh yes. Well, you need a guy. You need a man and woman to have a child, but why marriage?
Because that's what society viewed that was moral. That was the correct way of doing
You're
it.
giving the conclusion, not the justification, right, Michael? What's the link between marriage and children?
Usually when you're married, you have children.
Well, usually when you get married, you have children, but you can have children without marriage, can't you?
Yeah. Maybe it's like that's what happened, back in the day, to maybe get people to have children.
Well, you think people got married to get them to have children. Let me ask you the flip side. What happens to people who have children who aren't married?
Yeah, it's like against the morals.
More practically, morals for sure.
Yeah.
But what happens to people who are married and don't have children? I'm sorry, people who are children but don't get married.
The children are like a bastard, seen as a bastard.
Well, but why are they seen as a bastard? That you tell me the conclusion. But why did society create a stigma, illegitimacy, on kids of unmarried parents?
You say it's an easy question.
No, it's not easy. Angela, help us out, my friend. We have a guest here, so I'm going to skip him. What's the linkage between marriage and children? Why did society place certain burdens, stigmas, on the children of unmarried parents? It's a very easy answer, but since what do you mean?
When you have kids, you want to be married. You don't want to be like single because then it's a hardship on one parent to take care of.
Oh, so you're saying, think of it from the child's perspective, right? Where is a child more likely to have a good upbringing? With one parent or two? That's the answer. It's such an easy answer that people don't see today because we have different family structures today, right? Historically, the greatest chance of survival for a child is having two parents, not one. It's simple. And marriage was designed to keep the two parents together. Divorce today can be obtained in 5 seconds, but at common law, you couldn't get divorced. Marriage was a union for eternity, right? Till death do you part, or something like that, right? Marriage developed not through central planning, but through spontaneous order in every sense of the word. That society determined the best way to have productive families with children who can survive to adulthood is by having a stable home, two parents. And indeed, to discourage people from having children outside of marriage, you create the concept of illegitimacy. He said bastard, right? You put disabilities on the child. You make it a crime to have sex outside of marriage, right? The entire structure developed to give the children the best chance of success. Now, whether that works or not, we can have arguments for the end of time, right? There are plenty of mom and dad who are miserable parents and plenty of single moms that are really good parents, right? There are going to be plenty of gay parents a hell of a lot better than single parents. we can argue, but historically, one second, Matt, I promise. But historically, marriage developed as a way to help the kids. Yeah.
Did the issue of property inheritance have much to do with that as well? I could see, illegitimate children trying to claim property versus.
I think marriage predates inheritance.
Sure.
I think as an institution, marriage existed in colonies that had no property, right? They existed in cultures that don't have the concept of private property, right? I mean, the Kalahari Bushmen, I think, as a reference in the opinion, just completely worlds apart of what we know. But
the concept of private property.
I don't know enough, but I don't know.
Right.
Yeah. But these are cultures that just didn't have any sort of common thread other than the idea that to have two people raising a child helped. Now, wasn't just two. A lot of these cultures, it was 3 or 4, right? They have polygamy. Indeed, if you ask me, I think there's a much stronger claim to having a right to multiple marriages than same-sex marriages, right? Polygamy is a hell of a lot stronger constitutional argument than same-sex marriage, because you actually have cultures going back time immemorial, even in the 19th century in America, where you had polygamy fairly common. I think polygamy is a lot more deeply rooted than gay marriage ever will be, but what do I know? Apparently, I go to the bathrooms in Minneapolis. What do I know? Yeah, take a wide stance. Fun. I actually had I was in law school the night that story broke, and my classmate actually worked for that senator from Idaho, and just a look came over her face like, oh my God, because she loved this guy, respected him, and just Google Larry Craig Minneapolis, you'll see it, or maybe not. I don't know. Don't Google anything I tell you to Google. Just don't Google anything. It's bad. Stay away from Google. All right. So the reason why marriage laws historically, forget marriage laws, why marriage existed was to help the children, right? Now that doesn't get you all the way, right? Even if marriage developed as an institution that existed for millennia, new laws were passed in the 1990s and early 2000s, right? And these laws were passed in direct response to fears about gay marriage. So even if marriage developed as a way to promote responsible child raising, a lot of these subsequent laws were enacted to prevent gay couples from having the same protections. Now, why does that matter? We ask always about motivation, right? Were these laws designed to preserve morality? Were they designed to exclude gays? Or does it matter, right? This is very much the issue with the Defense of Marriage Act. Destiny, you want to give me the facts, please, in Windsor?
So Windsor and her wife got married in Canada, and then they moved. And under Canadian law, they was married when they moved. They were no longer seen as state laws in the movie.
Good.
And so under DOMA, because DOMA defined marriages between man and woman. And so they sued. When Windsor's wife died, she wanted the tax payment.
Good.
And she was denied it because
Good.
of the.
Yeah, have you taken tax yet or no? You haven't taken tax yet, right? All right, so thank you, Destiny. Very good. Generally, when you're married, you get to inherit certain properties tax-free, certain money. But because Windsor and Thea Spire were not married under federal law because of DOMA, she had to pay an inheritance tax. It was like a few $100,000. It was actually a lot of money. A lot of money was had. By the way, if they had set up a trust, they could avoid all this, right? Even before gay marriage, gay couples were able to basically approximate marriage by setting up trusts, right? There were even cases, now it's going to sound gross, where there was a gay couple, one adopted the other, such that they would inherit all the property. I know you're saying, how could that be, Josh? It happened very frequently, right? Because you just inherit as next of kin, right? As if you were, I'm serious, right? There have been cases where you have these sort of elaborate arrangements set up to avoid the prohibition on gay marriage. I read one case where it was actually a guy adopted his girlfriend to prevent like the ex-wife from getting money or some weird, people do crazy stuff like this all the time. I stopped myself, I stopped it. Yeah.
Can you adopt an adult?
Sure, you can adopt anyone. You can adopt a child.
Well, like the child's different than an adult.
But no, but of any age, you can adopt anyone, right? I mean, if you're a legal guardian of someone and that person's over the age of 21, you can still claim this as dependent on your taxes if they're actually a dependent. You can adopt it.
To a certain age, not like indefinite.
I think you can. If you have, for example, you have a disabled child who's in her 20s, you can still claim it as dependent. I don't think there's an age limit. But yeah, adoption. There's no limit in adoption. It's just a legal status. It's not just whether you're taking care of them. Yeah, it's stuff the last day of class, right? So Windsor sued for a refund of her inheritance tax. Okay? She sued for a refund of her inheritance tax. The Obama administration declined to defend DOMA because they determined it was unconstitutional. As a result, the House of Representatives intervened. And I want to play one exchange for you from the oral argument. And this is an exchange between Justice Kagan and Paul Clement. Paul Clement was a lawyer representing the House. And the discussion is, why was this law enacted, right? Was this enacted to deal with the situation of couples moving from state to state? Or was this law enacted because Congress disapproved of gay relations? So let me just play this clip for a minute.
Justice Elena Kagan and Paul Clement foreshadow the outcome of Windsor. Justice Kagan observed that in 1996, the House of Representatives explained that DOMA would
reflect and honor a collective moral judgment.
Right? In other words, the Congress said that they think that heterosexual marriage is moral, but homosexual marriage would not be moral. And that's what they put into the report about the law.
Expressed
moral disapproval of homosexuality.
She then asked Clement,
is that what happened in 1996?
DOMA was enacted in 1996.
Of course, the House report says that. And if that's enough to invalidate the statute, then you should invalidate the statute.
He didn't count it.
So basically, Paul Clement acknowledges that if you separate law and morality, then there's no basis on which you can prohibit gay marriage, right? There isn't. If straight couples get it, then gay couples get it as well. But he counters.
It's never been your approach, especially under rational basis or even rational basis plus, if that's what you're suggesting.
Rational basis plus is how Roma was often described. So, I mean, this is pretty ballsy, right? You go to the Supreme Court, you say, you know what, Your Honor, if you apply the traditional test, we win, but if you change your test, we lose. He was being candid, right? If you apply this new test, you go strict scrutiny on us, we're going to lose. And that's pretty much what happened. So the upshot of Windsor, and I don't know how important this case is. I really, Randy wants to take it out of the book. Maybe I'll agree with him eventually. I think it's important for the chronology. But Windsor basically just set the stage of saying Congress can't define what marriage is. And at the very end, right, the very last sentence, Kennedy says, but this decision only applies to lawful marriages. In other words, we're only talking here about marriages approved by state law. We're not saying whether the states are required to give marriage licenses. No one believed it. Remember Scalia said, do not believe it? No one believed this at all. I mean, just it was not even remotely plausible. Okay. Yeah, I'll give you a little Scalia.
To disparage, injure, degrade, demean, and humiliate our fellow human beings, our fellow citizens who are homosexual.
There it is. That's not Scalia for now. Okay. But everyone recognized that once you had Windsor, the state prohibitions on marriage no longer could stand. They couldn't. In fact, almost immediately after Windsor was decided, lawsuits were filed across the country challenging marriage laws. And they all cited Scalia. Right? Scalia said, this leads to gay marriage. And all the lawyers said, Scalia's right, this leads to gay marriage, right? So, and all these judges like, oh yeah, we're citing Scalia, also smug, right? They did. And that gave rise to Obergefell, which came a couple years later. Oh, here we go. This one I want to play.
For today's majority, as it is going out,
Lawrence, a decade earlier, Justice Scalia.
And we're in the same thing.
It takes real cheek for today's majority, as it is going out the door, to leave us with that comforting assurance, when what has preceded is a lengthy lecture on how superior the majority's moral judgment in favor of same-sex marriage is to the Congress's hateful moral judgment against it. by formally declaring anyone opposed to same-sex marriage as an enemy of human decency, the majority arms well every challenger to a state law restricting marriage to its traditional definition.
He concluded,
the court has cheated both sides, robbing the winners of an honest victory and the losers of the peace that comes from a fair defeat. We owe both of them better. I dissent.
There it is. Okay. He didn't actually drop his mug, but it would have been funny if he did. All right. Oh, that looks creepy. Okay. All right. All right. Questions on Windsor. Very important case of a time. I don't know how salient it's going to be in the future. There was lots of federalism, which Randy thinks was important. I don't think it really was. It didn't really matter about whether the federal government should even be defining marriage. Fine. But this was just basically a pit stop to Obergefell, which happened 2 years later. Any questions on Windsor? Okay. All right. Yeah, okay. So we have Bowers, then we have Romer, then we have Lawrence, then we have Windsor, then we have Obergefell in 2015. And this was basically a I guess almost a 30-year, depending on how you count, a 30-year slide from start to finish. All right, questions so far? All right, let's do, oh, and this is my favorite animations.
Justice Kennedy wrote each of the major decisions extending the rights of gays and lesbians.
That's how I view constitutional law the last 20 years, just that. I know I'm cynical, and I apologize. I can't teach this. I almost don't even want to teach this class. It's just, I don't know what the salient is going to be. I think these were cases that were decided, they're important, but I don't know what where they fit in any sort of arc. They just sort of stand alone unto themselves. It doesn't fit anywhere else. Okay. All right. Anything else on Windsor? All right. Let's go on to Obergefell. I used to make my students read the entire opinion, which is over 100 pages. Consider yourselves fortunate. I stopped doing that. I think the utility diminishes year by year. Was that? What, something? Anyway, it's a long opinion. It's like 100-something pages. I used to read the entire thing, but I stopped doing this. And a couple of years ago, Jim Obergefell, by the way, you pronounce it Obergefell or Obergefell? He came to Houston for some talk, and I was at Discovery Green, a couple miles that way, a couple blocks that way, and I chatted to him a bit. He was a really nice guy. We chatted for a few minutes, and I asked him to sign my Constitution. I have a collection of signed Constitution, of a lot of them, and usually I just open up to the front cover, but instead I open it up to the 14th Amendment. Like, oh, why not? And it's hard to see. You can pass this around. Here, I'll put this down over here. But he wrote at the bottom, it's hard to see, he says, love one, Jim Obergefell. Love, W-O-N, love one. Here, you can pass it around, please, thank you. Make sure I get it back, though. I only have one of those. But I think it's very fitting that he basically wrote under the 14th Amendment, love one, because basically there was a section added to the Constitution. I call it Section 6 of the 14th Amendment, the love clause, or the dignity clause, maybe. The decision, philosophically, I find compelling. I just have difficulty with the legal precepts. And so let's walk through this one step at a time. Caroline, you might just, the facts are obvious, but you want to give me the facts, please?
Sure, so
thank you. Yeah. Yes. Yeah. That was actually a very sad story. Let me pause you. Arthur was diagnosed with ALS. I think it's Lou Gehrig syndrome. It's also known. It's a very debilitating disease, and they wanted to get married before they died. So they basically were put on a medical transport. These are basically planes that are basically surgical centers, and he flew from Cincinnati to Baltimore, which was the closest state nearby. They were married on the runway, and they took right off, went back home, and then he died shortly thereafter. So it's very, actually, he told his story when I saw him. It's a very compelling story about these two people who were deeply in love. All right, Caroline, go ahead.
So Ohio would not let you put his name on Arthur's death.
Yeah, so it wasn't whether they can get married, because they were already married. It's whether the death certificate could be modified to add his spouse as a decedent. Come on, have a seat. Okay. All right, so go on, Caroline. Okay, very good. There were cases across the country, and let me just briefly summarize litigation. Several courts of appeals ruled that marriage laws were unconstitutional. The Sixth Circuit, though, the Sixth Circuit Court of Appeals, where I clerked, I clerked before this happened, was the outlier. The Sixth Circuit covers the states of Ohio, Michigan, Kentucky, and Tennessee. And the Court of Appeals, in divided ruling, found that the marriage laws were valid. At this point, you had what's known as a circuit split, right? And once you have a circuit split, that virtually guarantees the court will take the case. But beforehand, all these courts declared marriage laws unconstitutional, and the court said nothing, right? The court said nothing. As a consequence, you basically had these decisions just pass over. And it became really clear the court was not going to reverse. All right. So you had these 4 cases go up, and the court splits in Obergefell 5-4. And of course, Justice Kennedy, who else, right, authored the majority opinion. The court acknowledges that marriage is this old institution. He writes about the transcendent importance of marriage. The lifelong union of a man and woman has always promised nobility and dignity to all persons without regard to their station in life. The court acknowledges that when marriage was discussed, it meant marriage between 2 people, people of the opposite sex. But like with the Lawrence decision, views on marriage evolve. Query, how do they evolve? Do they evolve through judicial decisions or the democratic process? Kennedy says that the view long held about opposite-sex marriage is held by good faith, by reasonable and sincere people, right? They're not trying to demean marriage. Rather, they're saying that marriage has perhaps evolved. Okay? Then the court walks through case law, right? The court walks through all the case law. And what cases he cite? Bowers, Romer, and Lawrence, basically cases that he wrote. So basically what Kennedy did was he built up a line of precedents which then he relies on to declare the marriage law as unconstitutional. What's that? Thank you. Thank you, Nick. Yeah, passing stuff around is always very hard. People have to get around and walk. That's why I hate sign-in sheets, because people always have to like go around the aisle. The app makes my life much easier. Okay. So now we get, Ray, let me call on you, sir. We get to the actual basis of the decision, right? Is this an equal protection case? That is, we have a suspect classification? Or is this a due process case that there's a constitutional right, a fundamental right to have a marriage license? What is the basis of this decision? Okay. And specifically, what is the right that's being protected?
The right to marry, the fundamental right to marry.
Okay. Yeah, so how does the court, Ray, this is my question for you. How does the court go from marriage being traditionally a right of opposite-sex people for thousands and thousands of years to here marriage being a right to whoever you want? How does the court bridge that gap?
He cites Loving, where they had an interracial marriage. Then he cites Zablocki.
Yeah, Zablocki, good.
Fathers behind on his child support that couldn't marry. They went in and invalidated that. And they had the Kerner case. Prison inmates were not eligible to marry. I bet they invalidated that as well.
Very good. Right, so there's certainly precedents that suggest marriage is a fundamental right. But in all these cases, of course, marriage was also understood to be something of opposite people. The concept of same-sex marriage didn't exist anywhere in the world till the late 1990s or early 2000s, depending how you count. Kennedy recognizes this, and he says, we acknowledge its history, but 4 principles demonstrate that marriage should be extended with equal force to opposite-sex couples. Okay? I'll walk through these. I don't expect you to understand them. Like I'll do my best, but these are. Yeah, when judges say there are 4 principles, right? Where do you get these from? I don't know. Why these 4? I can't tell you, right? Kennedy writes first, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. That is, people can make decisions about themselves. There's dignity in the bond between two men or two women who seek to marry. What's dignity, Sergio? What's dignity? This word keeps using throughout. What does dignity mean?
I mean, I think it's just an extension of liberty and your, like the rights that you have, whether they're fundamental or not. In a sense.
What's Sergio, come on, man. What's dignity? What does that mean to have dignity?
I mean, it's morals.
Morals. Ooh, Matt.
The state or quality of being
Did you just look up the dictionary? Smartass. Okay. So, which dictionary are you using? Google.
Let me see. Oxford.
Oxford. Okay, so read it for me, please.
The state or quality of being worthy of honor or respect.
The state or what?
The state or quality.
The state or
of being
quality.
worthy of honor or respect.
Okay, what does that mean? What does it mean to be worthy of respect?
Cannot be looked down upon because of some difference or, basically to recognize that, humanity of the person.
Humanity. Okay. Anyone else want to add something? Yeah. You want another dictionary?
Referring back to his opinion in Casey.
Casey. Okay.
Certain things a person needs to be free and whole.
Okay. So things you need to be free. Okay. Anyone else? Yeah. Self-respect. Okay. Anything else? Would you raise your hand? Yeah, Angela.
I said it's something like that you probably deserve.
Something you deserve. Okay. Anyone else want to add something? I heard another voice somewhere.
Pride.
Yeah. Pride. Okay. Pride. Anyone else? I can't say that any of you are wrong because I don't know what it means. Right? It's a concept that I think means a lot of different things to different people. I call on the 8 of you, however many I called on you, however many dictionaries you have, but I think this is a concept that it's a fairly deep philosophical concept that I think people of reasonable minds can disagree on. My only response is, as a judge, how are you to know what dignity is, right? If there was another case where a person says this law violates my dignity, how do you know what that is? What do you do with that, right? What as a judge can you do with that word, right? If the marriage law deprives people of dignity, what other laws deprive you of your dignity? The Constitution says nothing of dignity. It talks about liberty, right? Is dignity something you're born with? Is something that you deserve? Is something you earn? Is something that can be taken away from you? Justice Thomas seems to think it can't be taken away from you, that you're born with it. It's inalienable, right? We can debate dignity for eternity. The only question is what role does it have in an opinion? Sergio?
But doesn't that go to our government itself? That it's a representative government. We elect people to make these decisions.
We elected these people? These 5 lawyers?
We elect presidents. Some people elect presidents based on the court, changing the court. So, yeah, we elected a president.
But the people of Texas passed a statute and they decided that gay marriage should not be allowed. So why should the 5 judges make a better decision than the electorate? Right, I mean, by the way, Chief Justice Roberts' dissent here was surprisingly very angry, right? I want to come back to Sergio's point now. Roberts is usually pretty mild-mannered. He usually doesn't blow up, but he called the majority 5 lawyers. Not 5 judges, 5 lawyers. And he asked, why are we being ruled over by 5 judges who, to be sure, are appointed by presidents, but why do they get to second-guess the decisions of 70% of the electorate in Texas? There was actually a constitutional amendment in Texas and in most states by the ballot, which passed overwhelmingly. Yeah? Yeah. You okay with the 5 lawyers?
I mean, I just don't hold the state legislature to that much of a, I guess.
Well, this is people. The people voted on this. Was actually a ballot referendum.
It wouldn't have been on the ballot if it weren't for the legislature.
For sure, but I think that's 70% of the electorate voted for it.
But I had to get 70. We had to get 2/3 of each house too.
Sure. Which I think makes it even more legitimate, not less, that both the legislature and the people agreed on it. Right, but this is a question against substantive due process in general. Right? Why are judges in the business of second-guessing legislation that passes by such a wide majority when there's no express prohibition and that there's a long tradition of having these exact laws? Right. This is not like perhaps in Loving we fought a civil war to eliminate white supremacy. I can get Loving. I can see that decision. Right. The idea of having a ban on interracial marriage was actually fairly novel. It only come around, in the early 1900s, depending where you count in Virginia. The law was passed in the 1920s, whereas marriage laws have existed since time immemorial. But all this to say is, how should a judge know that this law deprives you of dignity? How should a judge know if a law demeans you or takes away your pride or whatever other synonym you want to use? Okay. It's a hard case to teach. I think it's a little bit easier every year. It's a little bit less recent, right? When it first happened, people were so ebullient. One second. People were so ebullient, like, yay, marriage. Okay, sure. I think Robert says you can celebrate the outcome, but not the reasoning. Yeah. Has Kennedy ever elaborated with word dignity means? Not with any precision. I don't think so. He's never in a book. He gives lectures and stuff. I don't think lectures actually shine light on this, but I can't think of anything.
I think the best way to understand what the word dignity means, especially in this case, would be having there stand next to you and have all of us ask him, what do you mean by
But why would that even matter, though? But I want to address this point. Okay, so sometimes you watch a movie, right? And then you watch the DVD and there are like deleted scenes and director commentary. I don't like that. I like the movie to stand by itself, right? I don't like someone coming after us. Here's what we really meant, right? So even if Anthony Kenny stood right next to me and told me what dignity is, like, I don't really care what you think. You should put in the opinion, right? You should have put in the opinion. You're just telling me now just to try and justify your decision. So I see where Sorosha's going with this, but like, he's not a judge anymore. His opinion's irrelevant. He's like the guy going to the Arby's box and yelling at it just on the drive-through. Sir, this is an Arby's, right? That's basically, sir, let me tell you what dignity is, sir. This is Wendy's. What are you doing? Pretty much, yeah. So it wouldn't really matter because the other 4 people may not agree with him. I think you have to judge the opinion by itself. What was that?
I just said, what were the odds that you would say that? Because we always make that joke.
About me?
No. We always say, like, this is a Wendy's, like, as a joke, and you said that. So.
That's what I think of Kenny opinions. Like, sir, this is a Wendy's. But he's publishing a Supreme Court justice. Oh, God. Good thing I did the evals last week. Anyway, yeah. But, yeah, so Sorosha, I don't think it would matter because it's what's in the opinion. And I really think it doesn't matter because I don't think this will ever get 5 votes again. Right? These were just opinions good for the time that they were decided. All right, let me go through the other 4, the principles, the other 3 at least. The second one, he says the right to marry is fundamental. So he actually uses the word fundamental. That's rare. Right? He doesn't ever talk about a right to fundamentality before because this is a fundamental right. He says this marriage right is fundamental and it supports a 2-person union unlike any other in its importance. Right? Now, why was marriage a noble purpose? It dealt with procreation. Of course, some married couples can't procreate for whatever reasons, health reasons, of course. But as a general matter, the society can say we want to promote this to help responsible procreation. Outlaw to outcast may be a step forward, but does not achieve the full promise of liberty. Sir, this is a Wendy's. Sorry. The third point, though, I think is a very good policy argument, that it safeguards children, that having a child growing up in a home in which their parents are deemed second-class citizens does have an impact on the child. I think that basically was one of the persuasive arguments overall, that if gay couples were allowed to adopt or have children through surrogacy, perhaps, then the kids are actually saying, why is mommy and dad, or mommy and mommy not married, right? I think that argument does have something. There's a stigma that attaches to it. Then he says, marriage is a keystone to our social order, and same-sex couples may aspire to the transcendent purposes of marriage and seek fulfillment in its highest meanings. Again, this is the transcendent dimension things. I don't know what this means. This sort of Eastern stuff, I don't know. I'm not qualified to teach you what that means. All right. And that's basically it. There's a lot more to read. There's some stuff equal protection, liberty, and dignity. But we get to the end. He says, under the Due Process Clause and Equal Protection Clause, it's both of them. Couples of the same sex may not be deprived of that liberty. The court now holds that same-sex couples may exercise the fundamental right to marry. See, keyword fundamental, so you know what they're going to strict scrutiny. No longer may this right be denied to them. And that's it. What about democracy? When there's a fundamental right at stake, we don't let the democratic process take hold. Of course, is it fundamental? That's the question. Great.
Individual dignity and autonomy. Do you ever see that popping up in the future, like reference, or is this one of those things that the idea?
I think that idea lost its relevance as soon as Justice Kennedy retired. I don't think it matters. Look, if this was Elena Kagan writing this opinion, she would have said, this is a discrimination on the basis of sex. You apply heightened scrutiny. Done. I'd be okay with that, right? Judge Posner wrote an opinion arguing that this was heightened scrutiny and equal protection. I'm okay with that. I think that makes sense, right? I wouldn't object to it. I think I wouldn't have the same sort of Wendy's shtick if I had that sort of opinion. But what I have the shtick is it's a sort of language that's just it's gibberish. It's nonsense, right? It's a person who thinks he knows what he's doing, and people need his votes. So they don't tell him you're wrong, right? It's when you're in a position of power, people need you. You don't get criticized. I think that was why Kennedy became who he is. No one ever second-guessed him in the majority to say they need the vote. He was, even if you watch his confirmation hearing in '87 or '88, he was talking about dignity and autonomy. He was using these words, and just it. I don't know. Wendy's. Okay. But anyway, we don't wait for legislative action. Dignitary wounds cannot always be healed with a stroke of a pen. Okay. And this conclusion. No union, these are like wedding vows. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than once they were. As some of these petitioners in these cases demonstrate, marriage embodies a love that endures even past death. It would misunderstand these men and women to say they disrespect the idea of marriage. They're pleased that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. Okay. Any questions on that? All right. We have 4 separate dissents. And it's kind of complicated. Not everyone joined each other. It's weird. Roberts wrote a dissent that Scalia and Thomas joined. Scalia wrote a dissent that Thomas joined. Thomas wrote a dissent that Scalia joined. Alito wrote a dissent in which Scalia and Thomas joined, but not Roberts. I don't know exactly why they did this weird thing, right? Why they joined some at all. I've been thinking about this for years. I don't exactly know. But Roberts didn't join Alito, and Alito didn't join Roberts. So take of that what you will. The Roberts dissent is surprisingly bitter. He's usually more of a statesman. He usually tries to build relationships. But here he attacks his colleagues as 5 lawyers. And he analogizes this case to Lochner and, of course, to our favorite Dred Scott. Right? Whenever you see a comparison to Lochner and Dred Scott, you know there's no real argument. Just it's sort of like guilt by association. But he says that these are the same sorts of decisions. Right? Roberts says, people can rejoice at the decision, and I don't grudge their celebration. But for those who believe in government laws, not of men, this approach is deeply disheartening. Okay? The right, the court announces, has no basis in the Constitution. This is Lochner. This is just Dred Scott. Okay. All right. Any questions in the Roberts dissent? One note, which I do think this is important. We had talked about the deeply rooted test, right? Whether a right's deeply rooted in history. That was a test that was adopted or used in a case called Washington versus Glucksberg. Roberts seems to suggest that the deeply rooted test was overruled, right? Because of course the right to gay marriage can't be deeply rooted. It's like 5 minutes old, right? It's brand new. Kennedy doesn't overrule the deeply rooted test. He simply says it doesn't apply here, right? That's all Kennedy does. We don't make any decision. We just apply it to this case. I think, and my humble prediction, is that the next time we have a substantive due process case without Justice Kennedy in the majority, we see the Glucksberg test make a comeback. We talk about whether the right's deeply rooted. And I can make this prediction with some confidence because during the Kavanaugh and the Gorsuch hearings, whenever they were asked about substantive due process, they kept saying deeply rooted, deeply rooted. And the senators weren't smart enough to ask about Obergefell because they don't know what they're doing. By the way, the Senate hearings are awful. We should have actually lawyers who know what they're doing asking questions, not senators making grandstanding points, right? A smart lawyer could have pinned down Kavanaugh much better than any of these senators could. They don't know what they're doing, right? So, but I do think that the deeply rooted test will make a comeback. I don't think it was overruled, so I think it's still fair game. Roberts also talks about polygamy, right? Why 2 and not 3? There's no answer. In fact, during the oral argument, one of the justices asked about polygamy, and the lawyer had no answer. Like, well, polygamy is different. Why? Well, it's different. There was just no real answer. Again, I think there's a stronger constitutional case for polygamy than there is for gay marriage. All right. All right, blah, blah, blah. Anything on Roberts? Yes, Ruben?
So what does that mean for future decisions when it comes to the right to just change definitions?
So what do you mean right to change definitions?
Well, the fact that they're just changing the definition of marriage.
Well, that's not what Kennedy says, right? Kennedy does not say they're changing the definition. He says marriage is actually about love between two people. It's not about procreation, right? In other words, even though we traditionally spoke of marriage as something about procreation, the actual fundamental right of marriage is something broader. So it's not changing it. He's actually doing what it always kind of was. Does that make sense?
I mean, I see your perspective.
I don't necessarily agree with it, but the court seems to suggest that what makes marriage fundamental is not just that it can be procreation. It's about the union between two people, and that's what's being protected.
Adding on to Ruben's point, would it be rather like he's reinterpreting what it means rather than redefining?
Reinterpreting. I don't really know. I mean, this is a general point I can discuss. How do you define a right? Do you say you have a right to abortion? Do you say you have a right to contraception or a right to privacy? Right, depending on what level of generality you use, the answer comes very different. If you have a right to privacy, yeah, that includes contraception, includes abortion, includes sodomy, includes everything, right? If you have a right to dignity, which is what marriage is, of course you have the right to marry whomever you want, right? So depending on how broad you define the right, the outcome looks very different. All right, let me talk about Scalia for a minute. Again, I think by this point Scalia had more or less come to terms with the decision. He understood that he lost, right? He understood that that this wasn't going his way, and that things were over. And he's accepting it. He says today's decree, not a decision, a decree, says that my ruler and the rule of 320 million Americans coast to coast is a majority of the 9 lawyers in the court. Sergio, this is your point, right? Who's in charge? Is it the legislature, is it the people, or is it 5 lawyers in the Supreme Court? He speaks about the most fundamental freedom is the freedom to govern yourself, which you don't really think about much. This decision gets in the way of the democratic process, and it ends the debate over this social issue. He then attacks his colleagues in many, many ways. He says we have 9 lawyers, all from Harvard and Yale, all who grew up in the East and West Coast states. Only one hails from the vast expanse in between. That's Roberts from Indiana. Not a single Southwesterner or even a general Westerner. California does not count. That's Kennedy from Sacramento. No evangelical or Protestant. There are 5 Catholics and 4 Jews. Right? We have a select patrician, highly underrepresented panel of 9. No, Gorsuch, we actually have a Westerner. He's from Colorado, I suppose. And he oh my God, there's so many things to say. He describes sir, this is Wendy's approach to the mystical aphorisms of a fortune cookie, the Kennedy opinion. He describes the style as egotistic, extravagant thought. He says, one would think freedom of intimacy is abridged rather than expanded by marriage. That is, you're more free when you're not married. Marriage makes you less free. And then he says, ask the nearest hippie. So I think David Crosby actually said Scalia was wrong. He went on TV or something. He's a hippie. This stuff diminishes the court's reputation for clear thinking, sober analysis. He describes the majority as engaging in hubris. Oh, he was just livid. Okay. Any questions on the Scalia dissent? I could teach a semester on that one, but I won't. All right, then we get to Thomas. And Thomas makes a different argument. He argues that liberty is not a government entitlement, right? You don't have a liberty interest in a marriage license, right? Freedom is freedom from the government, not a license. And he says it's a mistake to think of dignity as something that can be taken or given away. You're born with it as an inherent right. And this was people didn't like this one either. Any questions on Thomas? Okay. Then we have Alito. And Justice Alito rehashes the responsible procreation argument, the notion that we have marriage to ensure the best chance of success for children. Whether that's true in every case is separate because the state can make a rational judgment at what's permitted. Alito also worries about religious freedom and that this decision may intrude upon people who adhere to the traditional view of marriage and don't accept the Kennedy approach. Okay, I think I'm done. Questions on any of the dissents in the majority? Questions on Obergefell? Questions on anything? Thank you all for a great semester. I appreciate it. Thank you so much. Thank you. Thank you. Thank you. Thank you. And I'll be around if you want to stop by later. Thank you. Or I'll be at Wendy's. I don't know. We can chat there.